the city of El Dorado as the plaintiff in this case in Butler County District Court appears by and through Miss Ashlyn Linscog, as well as her co-counsel, Stephen Aker. The defendant respondent, Danika Dickinson and Heartland, Save the Heartland or Protect the Heartland Inc, excuse me, appears by and through Daniel Yaza. All parties are appearing by Zoom by agreement today. We held, obviously, an in-person hearing on August the 14th, a week ago, and bifurcated the proceeding for a final argument today and a ruling. I did receive, part of the reason that the case was extended for another week was because of a late receipt through no particular fault of the petitioners, but of their memorandum in support of their motion that was filed, and then or the plaintiff's reply to defendant's memorandum in support and answer. And then I did give an opportunity for Mr. Yaza to respond to that. Any cases that were cited or any new issues that maybe were argued or developed on the 14th or as a result of getting that response from the city right before the hearing. So I have received as of the 19th, so 2 days ago, a defendant's memorandum in support of motion for judgment on the pleadings. This is a petition for declaratory judgment for the court to interpret the legal issues in this matter. And it's also an action that the court is ruling upon factually based on the pleadings that have been filed in this case, and it's a decision on the judgment of the pleadings. Additionally, this morning, right at 9 a.m., just for your information, Mr. Yaza, and I know you're always included in the emails, but Ms. Linscog sent me the City of Prairieville versus PV United because it's an unpublished case. I think it was about 45 pages. I did not see where it was attached to or filed with your pleading. And of course, unpublished cases should be attached. Again, the court took a look at that case, and I do appreciate the submission of it. And then, of course, I instructed everybody, no more submissions of anything officially after 9:15 this morning so that I could be ready for this hearing. We have really reviewed at the last hearing numerous cases. Maybe I think my first one that I looked at was in 1914, but certainly from 1933 to 2025. And then the case that's unpublished that I received, City of Prairie Village, Kansas versus PV United Inc. and Rex Sharp, another Johnson County District Court case, appeal number 126881. It looks like that was, the opinion was filed March 7th of 2025. That may be our most recent case that we've discussed. But I think there's been a pretty thorough review of the case law. Certainly the case law as it pertains to KSA 12-3013. Now, there are a whole lot more cases probably that are just straight zoning cases that do not involve citizens petitions or matters being reviewed under that particular statute. And I think we've talked about some of the ones that, you know, maybe have some important aspects that we could look at that would be helpful. But we didn't take an extensive deep dive into every single zoning case that's been heard from 1933 to 2025. But I do feel comfortable that we've looked at the case law and discussed the case law. If we don't discuss it today, we discussed it and the court commented and discussed it with counsel on the 14th in consideration of part of this ruling today. Anytime the court made commented on a case, distinguished anything, noted any particular rulings, variance in facts of each case, which is really important. Those are noted for the record, whether they're cited in the opinion that I issue today or not. They're all part of the record in this matter. So I will comment, though 2024 case involving City of Prairie Village. I know the city probably wants me to find it directly on point and in the city's favor, but I don't think it is directly on point. It does reaffirm the things that we should be looking at or the court should be looking at in its ruling. But it wasn't a straight 12-30-13 case or action. Part of the issues there arose under KSA 25-3601A involving a change of governance and how the city was governed in terms of a commission manager form of government. So they were trying to do some big things, change how zoning's adopted in that city, change how their form of government is established and their form of governance, and pretty involved in that respect. Although, you know, clearly they did touch upon 12-30-13. And as I indicated, there may be some things that Ms. Linskog or Mr. Yaza want to argue today with regard to that case that perhaps we didn't address at the last hearing, but it is unpublished. So it can be persuasive if there's no other cases on point, and certainly the court can consider it, but I don't think it has the kind of precedential value. We also talked about some of the cases being Court of Appeals, Supreme Court, and then some published and some unpublished, which council knows how that sort of affects the order of things. So having said that, I think we may or may not have a few housekeeping matters, but I want the parties to have an opportunity to address anything or any loose ends. And then I would like to give you a chance to do 15 minutes of closing a piece if you want to utilize that much. Hopefully that's enough for you today. And then the court will rule from the bench today. We have, as we previously mentioned, tried to expedite this case as much as possible. This petition and action was filed on July 14, 2026. Due to some unexpected events, we couldn't resolve it on the 14th, but we will resolve it for purposes of the district court and the assignment to me and the decision that I'm making from the bench today. I think one of the things that I wanted to go over with both of you is whether or not Danika Dickinson was a circulator of the petition. I know it's been filed. We're already in volume 3. And I don't know. Some documents have been over 100 pages. And I know that the petition, and I believe the signatures and all of that were attached. I can tell you that I didn't look at every single signature because it had been certified. And so the form of the question was proper. The number of signatures was proper. And so I didn't delve any further, but I would have to dig back through that document and try to find her name or determine whether she's a circulator. So could there be a stipulation? I'm not sure, honestly, after looking at this Prairie Village case and some of the standing issues that were raised in that, as far as Mr. Sharp was concerned, that it matters whether she signed it or circulated or both. But I would like to note for the record whether she was a signer and a circulator or just a signer. Mr. Yaza, do you know that off the top of your head?
Yes, Your Honor. She was both a signer and a circulator. I have the packet here. I think not right this very second, but I could get you a page number because I believe this was in the city's first submission where they submitted the petition. So it's kind of in the middle of this 100-something pages where her page where she signed and where she signed as a circulator as well.
Okay. Well, the record will reflect that. I don't need anything further from you. You know, I took judicial notice of every single filing and exhibit and attachment, and it's all there to be examined. I'm appreciative that you could just point that out to me so we could establish that today. Any objection to that being part of the findings, Ms. Linscobb? Obviously, you submitted the petition with the signatures and the circulator identified.
That's right, Your Honor. So the reason that she was named out of all of the other signers was because she is the individual that was both circulated, had signed it, and then served it on the city as well. So it was her, it was Ms. Dixon that was the one that served it on the city clerk through the process in which an ordinance petition is submitted. And so that's why she was selected out of all of the signers, not just as a circulator, but also as the individual that served the ordinance petition on the city of El Dorado.
All right, very good. As far as you're concerned, are there any other loose ends or housekeeping matters that we should take up at this time?
No, Your Honor. I think the only sort of additional piece that I didn't know if you wanted to clarify for the record, and you did mention it, is that the parties had submitted a joint, what was it called? Thank you. Joint motion for judgment on the pleadings to allow the court to issue judgment on the competing deck actions between plaintiffs and defendants. The only housekeeping item that I would raise now for the court and for clarity about moving forward is that the motion, the agreed motion, just clarifies that it's the deck action is what's right for consideration, that the mandamus claim and the damages claim would require an additional evidentiary hearing as it relates to damages if the court were to rule in that direction. We just decided that because the competing deck actions were threshold issues, that largely dealt with the mandamus action itself, that we didn't think that should hold things up here. But just for clarity of the record, that those particular two claims are the claims that the parties have presented as ripe. And then the mandamus claim and any claim for damages would require additional evidentiary hearing.
Okay, very good. Yes, I will note and take judicial notice of it, as well as the other pleadings that I mentioned, filed by counsel. It was filed as requested by the court shortly after our morning hearing on the 14th. It was filed August 14, 2026 at 2:16 p.m., which I greatly appreciate. All right. Mr. Yaza, any matters that you'd like to take up?
No, Your Honor.
All right. All right, I'm now ready for final argument. Ms. Linscock?
All right, Your Honor. Good afternoon. It is approximately 175 degrees in my office right now. I'm confident that Mr. Aker, if we look at him wrong, he might throw something at us because of how warm it is in here. So if you see us start to sweat, it is our air conditioning isn't working very well. But I appreciate the time and the opportunity to be heard this afternoon, Your Honor. I may please the court. My name is Ashlyn Linscock. I represent the city of El Dorado with my co-counsel, Quentin Aker. And as we've indicated, Your Honor, we've spent a significant amount of time working through case law and McAllister and its progeny. And so I think that the arguments in the briefing made clear the various positions between the parties as it relates to where this case currently stands. If the court would allow, I will likely spend the bulk of the time allotted for the city's argument today and just addressing some of the issues that were raised in the most recent filing and working through those as briefly as we can, and not necessarily to rehash any of the additional case law that we've already worked through or the additional arguments that the city has already made. Of course, as always, Your Honor, if something becomes unclear or we need an additional point re-explained or rehashed, don't hesitate to interrupt. I hope that you wouldn't hesitate to interrupt me to direct or to get clarity. By way of a roadmap, that pretty much covers where I think that we're headed. I think that it's, again, important to acknowledge that this is a close question. That was why the city initiated this process in the first place. Also important to acknowledge that this isn't the only time that this question is arising. It is, anecdotally arising in other communities where these ordinance petitions on this particular topic are coming up. So I think we've discussed the facts at length. I do not think that there's any real dispute as it relates to the facts in this case, as the parties in the court have indicated. I think one of the initial places that I'd like to start, Your Honor, is over with the overall sort of argument or position the defendants have taken in their most recent briefing, and even maybe an argument last week, is that this was somehow to be designed as sort of a race to a policy question, and that specifically is relevant and or has bearing on whether or not this is administrative or legislative. Specifically, defendants have argued that because G1463 was passed within a short window of time before the ordinance petition was provided, everything is still new enough that it can't necessarily interfere with the administrative functions that the city had already deployed in adopting G1463. In doing so, and I'll discuss in a moment that the defendants frame the ruling in Inning as supportive of sort of taking that position. I think that it's important for this court to note as it works through the guidelines, especially under Guideline 1, when we're looking at whether or not we're operating on an existing framework or not, that Guideline 1 doesn't require interference to last a certain amount of time, or that there's any sort of temporal requirement beyond what has been implemented in a framework that exists, and whether or not there needs to be temporal consideration between the two acts. I think I understand that the court has had the opportunity to review the City of Prairie Village case, the 2025 Kansas Court of Appeals case. I would agree that there are a number of issues in those cases that are largely not relevant for our analysis here. I think the one that is the most relevant for this court to consider is specifically the court's analysis and ruling as it relates to the zoning petition in that case. And I think narrowly focusing the time that we spend there, again, is not precedential as an unpublished opinion, but certainly is instructive about the way that the Court of Appeals may otherwise interpret or apply the McAllister's factors in a case like ours. So under Guideline 1, I think it's important and to spend a little bit of time here because I believe the defendants spent significant time on this specific analysis, was that the approach that they're using here as it relates to this is that it's a policy question, Your Honor. So it's not necessarily a situation where we have an existing framework and they, that it's all based around policy and that otherwise isn't existing law being interfered with. I think that that's not necessarily the entire full view or the full scope of Guideline 1 as it relates to this case, specifically because the approach that the ordinance petition used did not sort of take its own mechanism to get here, Your Honor. It did not create its own freestanding existing mechanism in which this was going to be enacted. It relies heavily on and pulls architectural definitions on the city's existing framework in G 1463. Its definitional architecture includes, thresholds, data center definitions, same application, same use categories. It specifically carves out a subset or an island of those categories. And the city would submit that that is an execution or interference with an existing scheme, that it's not a freestanding new policy. Defendants cite the Emming ruling for this proposition that a petition can act directly on an existing scheme that has already been set up as long as it repeals it. And that would therefore make it legislative. And in doing so, they quote that the centerpiece of the ordinance in the Emming case is that the acquisition of the raceway and that overriding purpose simply outweighs the procedural details of the ordinance itself. And defendants rely on this pretty heavily to indicate that whatever procedural details may otherwise be in conflict between these two, the overall centerpiece is this distinction in policy. And then defendants take Emming and say, well, they acted swiftly, and because the existing framework was so new, G 1463, it had not yet been enforced, so the proposed ordinance therefore couldn't interfere with an existing long-term administrative function. I would submit to this court that there are three things that are incorrect with that particular statement or position. First, the Emming ordinance was legislation, or the reason that the Emming court held that that ordinance was legislative wasn't that it acted on an existing scheme on its own, but that its overriding purpose itself was a legislative act. So acquiring a raceway through star bonds, major public financing, and acquisitions. In that case, the acquisition was the centerpiece, and that's what made that legislative in character. So what Emming stands for is that if you look at the ordinance's overriding purpose and character, and if you apply that same test here to the facts here, that particular test defeats defendant's argument. The proposed ordinance in our case, overriding purpose, is to regulate land use eligibility. It's prohibiting defined uses across zoning districts, which is quintessentially a zoning function. So Emming's method, which is to identify the dominant character of the ordinance itself, applied to our facts, definitely yields it as administrative because the dominant character here is land use regulation. Second, the analogy fails because just on the facts themselves, Emming was about requiring a raceway and economic development. That has structurally nothing in common with the citywide prohibition of land uses that was already governed by the city's existing special use process framework. And then third, the argument around that I indicated that it's too new to interfere is specifically helpful when we both look at the Inning case itself, but also, as was discussed in the Prairie Village case, which Your Honor cited earlier in the hearing, which is the argument being made by defendants that because G 1436 is recent, hasn't been applied, so therefore there's nothing to interfere with because nothing has yet been done. But neither McAllister nor its progeny conditions the administrative character based on the existing scheme being longstanding or having already been enforced. In the Prairie Village case, that very specific zoning petition that is relevant at issue had not been even codified at that point. And the Kansas Court of Appeals found that it was administrative because it interfered with the execution of its existing zoning framework. So in our case, the ordinance had already been passed, adopted, published when the proposed ordinance was filed. So its recency, the timeline is irrelevant. What matters for this court to consider as it relates to that particular piece is that the proposed ordinance overrides what the city had already put into place. I think, that largely based on the arguments from last week here and this argument. The only other point I would make on guideline 1, Your Honor, is that defendants in their most recent filing attempt or do equate that new law has to mean different law. So defendants argue that the proposed ordinance adopts a policy that's substantially different from G 1463. So therefore, it's a new policy, which makes it legislative under guideline 1. I would submit to this court, Your Honor, that the slippage is in treating different from the existing policy as the same thing as a new law on a subject not yet addressed, because that is the guideline. The city has already made policy on this particular question on whether or how these land uses may or may not occur. The proposed ordinance doesn't address a question that the city left open, Your Honor. It takes the same question and it flips the answer. So new, if new were to mean that it's not identical to what already exists, then as the Prairie Village Court pointed out, every petition is new, and then guideline 1 would collapse altogether. And that was what the Court of Appeals was warning about. So new has to mean something narrower. It has to mean something along addressing a subject the governing body has not already regulated. And on that meaning, the proposed ordinance is not new because G 1463 regulates those exact land uses, Your Honor. The other section that I wanted to make sure to touch base on that we didn't spend a lot of time with last week is that we did talk about guideline 3, Your Honor, and that comes down to, does the decision require specialized municipal framework that most voters don't have and practically can't get before casting a ballot? That's quoting directly from the McAllister case. The McAllister court held that where it does, the decision belongs to the city's administrative judgment, even though it may also involve the establishment of a policy. We've talked through how the proposed ordinance turns on technical thresholds. It requires a 10 megawatt peak electrical load, 100,000 gallon daily water draw, 1 unit above or below, no special use, no consideration, no application, no mechanism that exists to allow the city to determine whether or not the city's water electrical grid can withstand those thresholds. It changes that discernment that the city has left for its administrative function and its staff in order to do that. I think that it's especially important to consider that in context, as it also relates to some of the facts that are on the record for this court, which is specifically some testimony and evidentiary record as it relates to the city engineer, who spelled out in the city's 2026 memo to the city commission that's also included in this particular case, Your Honor. It's page 11 and 14 of Exhibit 2 to the answer to amended petition. But specifically, the city engineer, Mr. Rickard, works through why the special use permit process gives them more city insight and more control. It allows the proposed location, surrounding land uses, site layout, access, utility demand, water and wastewater needs all of these lighting, noise, operating characteristics. The special use purpose is designed to allow conditions to be placed upon approval. Mr. Rickard indicates to the commission that this is important because El Dorado has valuable infrastructure assets, including water supply, treatment infrastructure, sewer infrastructure, street access, industrial land, and regional transportation connectors. The reason that I raised this for the court is because we didn't specifically refer to that level of technical experience at our previous hearing, but it is available on the record and was clearly considered at this place when the city was using its administrative function to determine how it would handle and regulate these land uses. I think that it's also instructive as it looks to the Prairie Village case, and then also McAllister, the City of Wichita Taxpayers Network. Both of those found the functions in those cases to be administrative because they required specialized fiscal and technical know-how. In the most recent briefing, defendants took the position that that there's some sort of additional balancing test that has to be weighed as it relates to that technological experience or that technical use. I have not seen and would not otherwise identify what those are. That's my timer, so I'm going to close for the court to allow defendants to take. And I would just close as briefly as I can, Your Honor, with the idea that first and foremost, because I think it's important for the city to state it as many times as possible, that the idea here isn't to win a race to a policy question with its citizens. The city's purpose here is to make sure that the law is being appropriately followed, that it is using its administrative function in the way that the statutes have designed for it to be done. It respects and appreciates the time that everyone has put into this particular question. It appreciates the court's speed in getting to this particular question, knowing that it took a heavy lift from court time and staff, Your Honor. And for the reasons that we listed both in the briefing and in last argument and today's argument, the city would request that the court rule that the ordinance petition itself is administrative and not legislative, and therefore an invalid use of the statute.
All right, very good. I didn't mention this before, but I'm not going to give you any rebuttal time because I'm not sure in a declaratory action that there's a particular burden of proof. So if you want 5 more minutes, I'll give you both 5 more minutes, but I'm not going to give any time for either one to do any rebuttal if you think it's necessary.
Your Honor, I don't anticipate needing additional rebuttal, unless Mr. Yoza gets up there and says really wildly crazy things that I absolutely must address. But to the extent I can, I'll try to make sure we stay out of his way and let him have his opportunity. Judge, thank you, though.
Okay, thank you. Mr. Yoza?
Thank you, Your Honor. The court, Daniel Yoza for Protect.
Yoza, I'm sorry.
You're fine. For Protect the Heartland and Miss Dixon. What McAllister did is change some things about the test. And the most instructive thing to me is that it centered the policy of that statute, that it's about democracy and voting and the citizens' opportunity to have a voice in their government. And I don't think this is like relevant for the ruling, but it's just an observation of all these cases that we've all read now, that every single one of these arises with some sort of conflict between a governing body and its citizens. Like there wouldn't be a need for a petition ordinance if a group of citizens went to their governing body and asked for a policy and worked through the process and were passed. It's really when there's that conflict between a policy direction of a city and the policy direction of the petitioners. And in any case, in this particular situation, it's kind of interesting. In last hearing, we talked about maybe a hypothetical where the petition ordinance had come in first before the city passed their ordinance. Would that change the analysis here? And the city seemed to admit that would be the case. But when we get into the petition ordinances under this statute, it's what my clients are asking for, which is an opportunity to vote on this particular issue. And the ordinance itself, just to go back to the analysis that we're required to make under the guidelines, it has a page that declares its policy goals. It has a page that defines a regulated activity. And then it has a page that lays out penalties and 2 sections for interpretation. Like that is the sum of this ordinance. It's a policy directive. It's not micromanaging the means or the ways of enforcing the city's new implementation of this new policy that the ordinance is setting up. That's in contrast to many of the other cases where if you just look at the ordinance, they're doing something different. In many cases, that's specifically administrative. The one of the reasons that we wanted to talk about the Prairie Village case is because it actually tells the governing body when it may rezone and not rezone particular things in the procedure. Like it's about procedure. It's about how they take rezoning applications. And as we've discussed before, first, this proposed ordinance doesn't address or approach the zoning process. And second, it doesn't micromanage the way the city were to implement this particular new program. I think that the analogy to this is to go back and talk about the city's police power. Like the city has this broad police power. Zoning power is a subset of that police power that's acted on through the statutes. But not everything a city regulates has to be done by zoning. And the city approached this topic from the very beginning as a zoning matter and decided to apply the special use permit process to it. But the reason we have this petition and the petitioners submitted it is because they wanted to ask a prior, more fundamental question, which is, should the city use its police power to prohibit particular types of industrial activities that are not right for the city? And that's a policy question that does not have to be enacted through a zoning ordinance, through a special use permit, through any of those things. Like the city could pass an ordinance to prohibit these particular industrial activities, and that's what the proposed ordinance does. These are some things that we just talked about in the last hearing. There's been mention in filings, and I'm not sure this was responded to in writing, but there's been some mention of the KSA 12760 appeal process. And in the defendant's view, that was not available because that's based on the reasonableness of a zoning action. And I don't think there's much contention among my clients that passing the city's ordinance was unreasonable in some way. It's not. It's an ordinance. It's just the wrong ordinance. It's a policy conflict between the two. So there wouldn't really have been an opportunity for them to challenge it under those grounds. The discussion of the first guideline that we've undertaken, like I said, has gotten very wrapped up in the idea that the city's ordinance established a baseline. It was first. It was new, and when the proposed ordinance came in, it acted upon it. And I think just reading the two, you have to agree that they have differences that have an effect on the regulated people. But I don't think that takes away from the ordinance being new, because it has a specific regulation on a specific party with a different means, which is prohibition as opposed to the discretionary special use permit, in order to enact that. So I think that's the key distinction there in the new ordinance discussion. When the um, when we approach the guidelines, and once again, this is from McAllister, they explicitly say that this is not a statutory interpretation question. Like the case law here is based on um, the idea that courts have the right to determine whether a ordinance is legislative or administrative. You know, obviously the words of the statute are there, but they're not basically defining what administrative is. They're using that history of the case law to make this weighing test that McAllister clarifies and lays out of being quite clearly and fully legislative and not principally executive or administrative. And I think the cases are all very instructive because we can look at those other ordinances and see how other courts analyze them to make that determination. And that's why I spent some time in our last filing talking about what those other ordinances did. I think Imming is particularly instructive because once again, back to our theme to begin with about, you know, conflicts between governing bodies and citizens. The governing body of Topeka wanted to bail out the racetrack. Like that's the story of Imming. And the citizens did not want to bail out the racetrack. And so the city passed a comprehensive plan to bail out the racetrack. And the citizens submitted a petition to just simply repeal that ordinance. In our case, it's a little different because the petitioners weren't interested, once again, back to that legislative, we're not interested in micromanaging every way in which the city implements its new special use permit policy. They wanted to address the fundamental question that underlied that regulation, which is, should we allow these industries in the city? And so that's very comparable to Imming, because in that case, the people did not want to bail out the racetrack. They did not want to spend the money. They didn't want to issue the bonds. And so, and that was their submission. And of course, like I said, you know, there's just a long trail of cases, and then there's all these reasons they're given for the guidelines. And so when you go back and compare to Fitzgerald, where, you know, there's wording in that case that seemed to say that, you know, when you repeal an ordinance, you have to look inside that ordinance and figure out if it's administrative. And if the proposed ordinance repeals an administrative ordinance, then that converts the proposed ordinance into administrative. So what, you know, it stands for is like, you know, that predominant test, where in the proposed ordinance, like the city has argued, and you know, we've provided response arguments to it, that perhaps, like, you know, the interpretation clauses that point out differences between the two ordinances, or maybe, you know, the fact that it uses cross-reference to a zoning enforcement provision as being administrative, but that predominant test, like, what does this ordinance do? What new policy is it trying to enact? Those are just different. One is a prohibition of these industries that the petitioners have stated the policy reasons for thinking should be prohibited, and you know, the city's special use permit that allows for them to be permitted, you know, following this administrative procedure. Which, once again, I think, you know, the petitioners were aware. I mean, were that of this distinction. There are times when repealing an administrative ordinance makes the petition itself administrative. And I think, you know, once again, I mean, the Prairie Village case going back is I'm now, obviously the proposed ordinance also, you know, micromanage the way the city addresses their own zoning applications and require for procedure and notices and all this stuff that's administrative. But I guess maybe thinking back to Fitzgerald and taxpayers, you know, the gun case, there was some thought in this particular ordinance that repealing existing city ordinances without really careful thought as to whether parts of them were administrative would be a danger to the survival of the proposed ordinance. So the thought was to not repeal or explicitly repeal specific provisions because of that danger of the proposed ordinance becoming administrative through those repeals. Let's see here. The third guideline discussion that we've had over the last week or so, I don't think we've focused on what that element really means, because I think every ordinance, there are some scientific or technical, or in like say a criminal ordinance, in what type of punishment should be given for a particular municipal offense. Like there are technical aspects to that, but that guideline doesn't mean that no technical thresholds can be used in proposed ordinances. Like that can't be what it means. If you look at when the third guideline is discussed, and we pointed this out last brief, it's always an internal city decision. The stormwater case was directly about, once you put stormwater in the ground and you start to charge assessments for it, you're paying off bonds. Like to unwind a system where you have debt and bonds and internal infrastructure, and all these things, that cannot easily be unwound. Like that's administrative. There's many of the cases have those sort of fact patterns where the administrative aspects that the courts find are administrative are for a reason, dealing with that, essentially meddling with existing city functions and procedures, and that is not what that third guideline was. I mean, that's what the third guideline was meant to address, is that adjusting a subclass of cities' pay to be equal to some other subclass of city employees' pay. Like that's an internal administrative city decision that's not appropriate for proposed ordinances. So in closing, I just wanted to circle back to those statements in McAllister that focus this determination on the desire of the legislature to give municipal residents a voice when their governing body doesn't hear them. And as you pointed out, I was doing some history reading, not as part of this case or anything, but this particular ordinance has gone back to 1909 to this particular statute, to the progressive era, like long, and it's controversial too. Like many legislators and legislatures back in that era argued about the idea of giving citizens the right to vote on their local laws at all. And there's diversity in our country about that, but this is a policy in Kansas that's been in effect for over 100 years. The legislature wanted it. There is case law that talks about the legislative versus administrative distinction, but I think the thing that needs to sit on top of that is the legislature gave the people the ability to have a voice in their government when their governing body doesn't hear them. And the proposed ordinance was drafted in a way to address those things in as much a high-level policy matter as possible, and not as a administrative meddling with city functions.
All right, very
Thank
good.
you.
All right, again, thank you, counsel. I really don't believe that the parties could have had better representation than what they've received in this case. And I do appreciate your work and your efforts. Now I'm ready to issue my opinion. The city of El Dorado is a city of the second class. Its population is roughly 13,000 people. It has a commission manager form of government or governance. It was the first city in Kansas to adopt this system in 1917. It also has a zoning planning commission appointed by the mayor and approved or consented to by the commission in order to implement land use regulations. It serves essentially as an advisory body. On June 1, 2026, at a public commission meeting, the commission adopted City Ordinance G-1463. Again, as I reference these things, they're clearly available in full text in the documents and the pleadings and those admissions in this case. It provided for a special use application and/or process for certain types of industries. The city claims since there was no existing zoning regulation regulating high-impact data centers and its functionally subordinate battery energy storage systems, commonly referred to by acronym of BESS, B-E-S-S, that if G-1463 was not adopted, developers could construct or erect a data center as a matter of right within the city. As a matter of notation here, just quickly, these facilities are also referred to at times as high-density data centers, hyperscale data centers, AI data centers, and energy-intensive facilities. Additionally, El Dorado is one of the few second-class cities in Kansas that actually has an industrial park. KSA 12-3013 EdSec provides a procedure by initiative and referendum whereby a city's electors may place legislative action affecting the city's governing body before the people for a vote. Initiative and referendum seem to be used interchangeably, but general use seems to suggest that an initiative is a new law brought forth and a referendum is an attempt to repeal an existing or recently passed law. Whether a proposed ordinance offered by a city's electors under KSA 12-3013 E1 is administrative is determined by the factual situation in each case, which is why we've spent so much time on each case to determine the similar facts, the dissimilar facts, to adopt some of the findings and to distinguish others. As we have noted through a thorough review of case law, the split is about 50-50, which means I have about a 50% chance of getting it right. My remarks, rulings, factual reference are supplemented by court records in the previous hearing 1 week ago. Petitions can be reviewed by mandamus action or declaratory judgment, such as in this case. Some states actually do not allow pre-election judicial review of an initiative or referendum actions that might limit intervention or create intervention of the purpose of the statute. Obviously, based on Kansas review of Kansas case law, Kansas has recognized court intervention pre-election in these matters. In response, on June 22nd, 2026, a citizens initiative petition was circulated and signed by at least 40% of the individual number of voters in the last, I believe, general election, but the last election under KSA 12-3013A, which was properly certified by the clerk, requiring the city to either pass without alteration or submit to the electors a proposed petition ordinance that would ban or outright prohibit, outlaw, if you will, the construction or erection of high-impact data centers as defined, and Tier 2 and Tier 3 battery energy storage systems within the city of El Dorado. Under KSA 12-3013A, the city has a 21-day deadline to respond. The city found the petition to be outside the authority of KSA 12-3013E, as it was believed to be a proposed ordinance submitted and administrative in nature. The commission adopted the recommendation and authorized this lawsuit. It then filed this action in district court under KSA 60-1701, a declaratory judgment, to request the court to determine as a matter of law that the proposal is not legislative as contemplated under KSA 12-3013, but administrative and invalid as a matter of law. The citizens claimed their proposal by and through defendant Danica Dixon, a signer and apparently circulator, and defendant Protect the Heartland Inc. is legislative in character and as a matter of policy and police power should be adopted by the court and go to the electors as a ballot question and issue. The purpose of KSA 12-3013 is to operate as an initiative or referendum process in support of a more direct democratic process and to be more directly responsive to the will of the people. By 1972, all 50 states adopted some form of initiative or referendum process. A land use measure can be altered or reversed by initiative or referendum if determined to be legislative, as established in City of Eastlake, a United States Supreme Court case from 1976. Widespread use of direct democracy is an important tool in shaping land use policy. Initiative, and what I'm referring to is an article entitled Initiative and Referendum in the Technical Service Land Use Process, report number 17, University of Denver, Denver School of Law. The guidelines the court must use and apply in considering whether the proposed citizens petition is valid, legislative, or invalid, administrative in character is found in McAllister versus City of Fairway, Supreme Court case 289 Can 391, issued in 2009. One crucial test for determining if an ordinance is legislative or administrative is whether the ordinance creates a new law or executes an existing law. Permanency and generality of application is considered. The city argues it has already established an existing law or ordinance dealing with the issue and has already adopted the same. Hence, the effort to pass a banning ordinance is an attempt to modify an already existing field occupied by this city administratively under the zoning code. This court does not believe the legislature intended that a recent action by a governing body that essentially beats the certification of a petition by weeks and less than a 30-day period as contemplated by court review would foreclose the ability of the citizens to submit a contrary initiative ordinance. And especially in light of the fact that the citizens petition is not attempting to tweak or change the language of the commission's zoning ordinance or procedure, but rather prohibits its application altogether as it relates to certain identified data centers. There is nothing ambiguous about what the initiative is trying to do or accomplish, or what it specifically would repeal. AI data centers are a new construct that the city passed a new law to regulate. The new field of industry, and the proposed petition would be a newly adopted law, ordinance, and exercise of police power that would prohibit such. This is a legislative function, not an administrative function of government. This is not a situation where the city has a long-standing ordinance or zoning provision on data centers. regulating a particular industry with contracts and city obligations, statutory or otherwise, that a citizen group several years or more later is trying to modify or regulate. In other words, it is not the citizens group intention to interfere with the function of government, although it may seem disruptive. It is addressing a new policy matter. And one additional case, counsel, and it's not a case, it's an attorney general's opinion that I looked at. Well, it involved Kansas Star Casino in Mulvane, city of Mulvane. And basically what they said is the state has already declared that Sumner County will be a location for a new gambling casino. And the city of Mulvane cannot disrupt services or any way declare that they are not going to be part of the casino itself, essentially. And part of that was there are already service contracts with the city in place. So the citizens could not come forward and disrupt and interfere with existing legal obligations, contractual obligations, determinations by the state government or any of its administrative agencies, and those types of things. And there's nothing here that's been presented to me anyway, that there's been any kind of negotiations or contracts signed, things of that nature. It's interesting to me that there are so many government entities engaging in NDAs with private enterprises, and I think that sometimes fuels some distrust or belief that there's something in writing or something that the city has bound themselves to that they haven't, just by virtue of the fact that those engagements aren't necessarily transparent and open to the public. Not in just this scenario, but in the Chief Stadium or anything of that nature where they want the government to engage in NDAs while they're entering into discussions or potential negotiations. But there's nothing that the city has that they've done that is jeopardized by virtue of the fact of the citizens coming forward and somehow asking that this issue go to the people for a vote first. So I think that's a clear distinction. It is also the proposed ordinance citizens petition is also permanent in nature. So, you know, I guess saying be careful what you wish for might be a dicta here, but it is permanent in nature as I see it anyway, in that if it's passed by the electorate, and that's if, it would be in effect for a period of 10 years by law, unless changed by the electorate. Acts declaring a public purpose and providing ways to accomplish that purpose may be generally classified as legislative. Acts dealing with only a small segment of an overall policy question are generally administrative in nature. A small segment of an overall policy with zoning would, in some of these cases, I think the clarification is that the zoning involved a specific piece of property, a specific located piece of property or zoned piece of property, a specific landowner that is being aggrieved by the zoning. Those are not a general policy issue, as the proposition is in this case through the statement put forth by the community. This proposed policy ordinance, however, clashes with the position that's been taken by the city officials. G 1963 allows the described data centers to apply for a special use permit to construct potentially a high-density data center, and the proposed city ordinance, citizens ordinance, allows no such application. The city could have prohibited high-impact data centers based on the community's desires or the overall welfare of the community as such, but chose not to do so. Enough citizens disagreed with the decision to bring about the initiative ordinance provisions triggered under KSA 123013. And as we talked about, or I did at least last Friday, the Wabaunsee County wind farm case, I think, was an example of where a particular identified, defined industry was prohibited in that community. Decisions requiring specialized training and experience in municipal government and intimate knowledge of the fiscal and other affairs of the city. And again, I'm covering the McAllister considerations and guidelines that I'm supposed to follow. And intimate knowledge of the affairs of the city to make a rational choice may properly be characterized as administrative in nature. In this court's view, the existence of or prohibition of a data center does not require internal, as suggested by Mr. Yoza, internal specialized government knowledge of particular intricacies of the government's role or function or responsibilities. It may require knowledge generally about the demands of a high-impact data center, but such is not a customary city function or usual daily operation with experienced governing bodies managing the same, like employment classifications, like pay grades, and those types of different functions, I think, in some of these cases, nor is it a utility question, which is a necessary component of government function to provide to its citizens, such as sewers and streets and roads and things of that nature, where considerations need to be made as to the financial commitments, the layout, the infrastructure, those types of things. If these data centers are prohibited, there is no need for any water usage analysis or electrical overload determination. It's not even necessary. Only if they are admittedly allowed to apply for a special use permit do these considerations come into play. Granted, a developer may suggest that some dormant commerce clause or some other legal implication exists by an outright forbiddance of their industry, and that it's not defensible under the law. But that is issues and litigation for another day. Perhaps even consideration by the constituents in making their decisions or in the campaign that the city may engage in. But I do not believe, I believe, number one, that would be conjecture on this court's part today. And I just don't feel that that is part of what the court should be considering future potential litigation as a decision as to whether this proposed ordinance is administrative or legislative, and whether or not it should go to a policy that should go to the people for a vote. Additionally, the city has argued that the proposed ordinance of the citizens that may involve some level of sophistication that's beyond me and maybe beyond most everyone, but that a developer could come in and develop something less than the proposed citizen ordinance, but with the same impact as what is described as a high impact data center as prohibited in the ordinance. Once again, I do not believe that this factor goes to whether or not the proposal should go to the people, but it certainly is a consideration for the voter to decide and make if the proposal may present more problems than it purportedly solves. This court has absolutely no way to know if the proposition will pass or fail. It must just decide whether it even gets on the ballot. Judicial or appellate scrutiny or passing legal muster is not a consideration for the court with regard to what may or may not happen down the road. I believe this factor supports a legislative finding. The city also suggests that the citizens could have taken a different path under 12-760. Any aggrieved action of the city that they could have filed an appeal for review in district court. In my view, first of all, I think the city admitted this isn't an exclusive remedy, that the citizens couldn't take the action they did under 1230-13, but if they had taken the 12-760 avenue, it's a whole different standard of review by the district court and the appellate courts as to reasonableness of the action of the city. And it's generally, as it's described, for an aggrieved party, not a group of citizens who want to take an issue to the electorate. When the matter at issue in a proposed ordinance under the initiative and referendum statute is one of statewide concern, and the legislature delegated decision-making power to local councils and boards rather than local electors, it is administrative. But there's been no such delegation by federally that I'm aware of, or by the state of Kansas to date, other than some matters that involve passing on of electrical costs to consumers and tax credits or something of that nature. But there's certainly been no declaration of a policy statement by the state that you cities or you counties or you districts need to allow AI data centers to come into your communities, or the inverse of that. You need to ban or not allow these things in these industries in the state of Kansas. I think the state could have prohibited citizens from interfering with the industry, as I mentioned last Friday, and give deference to the industry like they have with nuclear power plants and oil and gas drilling and refineries and things of that nature, and protected the industry if they had chosen to. Again, they have not preempted the field. The issue policy is not prevented either by the city of El Dorado based on its very recent passage of a regulation ordinance that it is attempting to do so with. No one guideline controls over the other when a court is asked to determine whether a proposed ordinance is administrative, as declared in McAllister under KSA 30-13E1. But they did find that it is a matter of weight, and weight can be given to any one guideline, or I would suggest any predominant overriding factor. And it may be enough to decide that an initiative ordinance intrudes too far into a city's administrative function, and it may not. I think that we can all concede that a city could not function or operate if every time they made decisions, there were citizen propositions that interfered with the normal functions of the government to provide services to its people or to make decisions affecting the welfare of the citizens. But I do think there are matters of concern that rise to a level of what is good for the community. And arguments can be made as to health, safety, quiet enjoyment to peace, waste, unwanted industries, all of those types of things. I do think there are matters that rise to a level that the citizens can step in and place an issue before the electorate. And the court finds that this is one of those propositions or petitions for an ordinance that should be placed on an election ballot. This court does view that it is important that the will of the people should prevail over any administrative functions or assertions so as to protect the power of the people to seek direct democracy that affects them. Additionally, I'm just making comment here. I don't think AI data centers have been deemed to be a necessity or an integral part of the function of government and planning for the people, like I mentioned, like roads, sewers, utilities, all of those things are managed by the city for the good of the common community. In summary, I do not believe that the proposition is submitted to the city and the petition is I believe its essential nature and character is legislative, not predominantly administrative. And lastly, I'm going to go back to the last couple of cases that we talked about. The court does find, the court doesn't have to find solely or purely legislative. We've talked about that. It can be a little bit administrative, but doesn't make it administrative to the extent that it invalidates this particular petition anyway. And the court must determine the facts of each case, which I did try to do in this case, and whether the essential character of the proposed ordinance is legislative or administrative. And this court finds that it is legislative. In City of Prairie Village, I think this is the one where, at any rate, hit the standard. I'm sorry. I wanted to quote it, and I'm sure it is in this Peter John case, that it cautions courts to uphold the spirit, the purpose of KSA 12-3013. And the court has taken that suggestion to heart and has ruled that the city must either adopt the ordinance, proposed ordinance, or place it on the ballot for the electors. Now, having said that, you, of course, have a right to appeal, and you certainly may do so. Again, you know, dicta or dictum is statements by the court that's not really part of their analysis, but they just like to throw in their 2 cents. But I do think that this may be a special question of statewide concern, that if there is an appeal, that it could be perhaps fast-tracked directly to the Supreme Court. Because as we talked about, sometimes in the appellate court between unpublished opinions and published opinions and, you know, 3 appellate judges versus another 3 appellate judges, there can be differences of opinion. And I suppose that's true with any case. But I just did want to mention that this is something that perhaps could be considered as one of those things to go to bypass the Court of Appeals if there's appeal. Again, it's just a thought. But I have a rule, you have a right to appeal. Is there anything that you would like me to additionally do or address? And if not, I am going to try to take my oral decision and file it on Monday with the proviso that it does not include every single case that we identified that we went over as part of the record on Friday. I know folks there were getting pretty glazed eyes after a while. I don't know. I think we were at it 2.5, 3 hours. I don't know, but it seemed like a very long time working together, talking about the cases, distinguishing them, arguing them. The court made commentary on them, just so the record's clear that the court additionally considered all those cases. But in my written opinion, every single case is not going to be covered in the way that it was, I think, or approached during the hearing itself. But there should be a sufficient record. All right. Anything further? All right.
So I'm sorry, Your Honor. I just wanted to give Mr. Yoza an opportunity to speak. As it relates to next steps in this case, based on the court's ruling, the decision as it relates to whether or not to put it on the ballot and or adopt the ordinance as proposed based on the court's ruling has to be made at a duly noticed commission meeting. Because the timeline for the city to do that had expired within the time frame of when this particular action was filed, the court's current ruling or current order is that timeline is told up until further order of this court. I know that the city has a commission meeting on, I think it's September 8th. Is that right? Is that right, David? Yeah. On September 8th, in order, and I can certainly get this particular agenda topic on the ballot at the next notice city commission meeting. But it won't be sort of immediate to the extent that this court had anticipated that would happen prior to then. So I just want to get clarity with the court as it relates to being able to have a little bit of time in order to have a commission meeting so that the body may otherwise make this decision on the record.
Well, the city filed this action in a timely manner to obtain a TRO that, again, there were some logistical issues, but that would have required a ruling by the court to provide what might be considered injunctive relief. And ultimately, after some discussions, because in all fairness to the court, as you suggested, the court needed a little bit of time, and injunctive relief restraining orders are more difficult now if we have to find who we think might prevail. And I know that's our job, but by the court not acting on that injunctive relief, and would have postponed a potential hearing, then the parties agreed to stay any further time requirements or constraints, if I'm articulating this correctly, in order for this decision to be heard. And I think everyone has acted, pretty quickly in putting things together, or submitting things, or that kind of thing. So I'm not sure what your thoughts were about what you were tolling and how long you were tolling it. But for instance, if it's 21 days, not 20, right? Or 20 days. Huh?
20, Your Honor.
Yes. Let's say if the 20 days starts to run today from my ruling, or Monday from my filed ruling. If you're telling me today's the 21st and the city will do one or the other, of course, there's a right to appeal, but you would have to get a stay from the appellate court. I'm probably not. I mean, I'll have to research that as to what my options are, but I don't know if I would do a stay. But you're still within the 20 days, right? Because there's 7, 14, 15, 16, 17, when the commission comes together. Correct?
Yes, Your Honor.
Okay. So is there a particular objection to that, Mr. Yoza?
No, I think what I heard there is that the hearing will happen within 20 days from Monday, in which the city will either decide to pass the ordinance or put it on the ballot.
Very good.
Or if
Yeah, because I don't want anybody to be disingenuous about all this, and then, someone I know everyone has to advocate, and I get that, but I don't, want that to be some kind of a defense to something that, hey, you didn't do this or that by this or that date. But I do know that timing, may be a matter of concern for either side in terms of depending on the decision that's made. But did I help you there? I mean,
Yes,
did I
Your Honor,
resolve what your question was? Okay.
Yes, Your Honor, I just wanted to make sure that there was enough time for the city to make sure it got on a properly noticed agenda in order for it to make its decision about whether it would be put on the ballot or adopted as proposed. The only other follow-up question and I don't know that there's anything this court could do right now, but when the court issues its final order, one of the things that the city's been doing in the background is making sure that should the ruling from this court ultimately be that it is an appropriate ballot question, that they have what they need in order to put it on the November ballot, because as I had indicated, the point was just to get clarity and then make sure that we were ready to move if and when the court were to rule. At this point, based on the timeline, although again, as the court has indicated, we moved this thing along just about as fast as the case can move. But as it relates to the timeline, I need to get some clarity from the county about how to make sure and or ensure that we can still get the ballot question, should that be the will of the commission, on the ballot. But I may be circling back to the court as it relates to getting some clarity or a court order for the county to be able to use in order to get it on the ballot. And I'm not raising that now for the court to make a decision, only to give an idea of where we might be headed, since we had done that, the city had done that work in the background.
Does it have to be published twice before it goes on the ballot or not?
I think there is a timeline publication piece that we have backed into a little bit, but I'm trying to get clarity from the county specifically. And I know David has been working with the county as well about just trying to make sure that we understood what the process would be. So my hope is that once we circle back and say, okay, we have clarity, we need to know what we need to do, then it won't be a problem. I was just raising it now, just in case
Right.
you saw a pleading come across this case, you're like, why are you back here? It is truly just to see if we can't make sure, because a special election is expensive, and
Right.
we just want to make sure that if this is going to go on the ballot, that it goes on the ballot as seamlessly as possible. Did I say that right, David? I don't know if you're at a place you can
Yeah,
unmute.
I hear what you're saying. I think
Okay.
probably Mr. Yoza's group would, I didn't really want to comment on this or consider it at all in terms of my decisions or my findings, but I would imagine Mr. Yoza's group would like it on the November ballot. That's where there's greater turnout. And I would think the city would like to avoid any special election costs that might go along with with that. So, but at the same time, everybody has to follow the election laws. And I don't think there's anything I can do from the bench that could alter the election laws as to how a question has to be placed on the ballot. But I'm happy to help in any way that I can. I'm happy to hold another hearing on any issues or matters that still may be lingering, or anything that needs to be done on the case. So if council would put their heads together, and if you've got an issue that the court can intervene and you want the court to, then I'm happy to figure out how to accommodate you in this case.
Thank you, Judge.
Okay, all right.
Thank you.
Thank you, everyone. We are adjourned.